Good day to you. This is Graham Paddock with another Paddocks Club video tutorial. Today we're going to talk about arrears control policies for community schemes. And let's start off by talking about the need. Why would you need such a policy? And what are we talking about? Well, the trustees of a sectional title scheme or the executives of an HOA should have a policy setting out how the scheme, its employees and agents will deal with arrear levies. And why is this? Well, sometimes schemes, some schemes in fortunate circumstances don't need to remind owners to pay or threaten to commence action against them to recover arrears. But for most schemes, arrears are a recurrent problem. Because the scheme's cash flow is so vital to its ability to meet its commitments to third parties and avoid penalties, arrears need to be dealt with efficiently and uniformly. I suppose you could just say efficiently. Does the National Credit Act apply to these arrears? Well, it's a question that's often asked. There was some doubt in this regard, but the short answer is that people were claiming statutory protection from the scheme or the HOA in their recovery processes. They were saying, I'm sorry, I'm protected under the National Credit Act. The position is now clear. The High Court in KwaZulu-Natal delivered a judgment in March 2010 which made it absolutely clear that levies are not credit. It's not a sectional title levy, and the interest thereon was held not to be an account tendered for goods and services provided. So these are collectives that recover amounts that they're committed to pay to third parties from their members. They're not giving people credit at all, in the sense in which that word is used in the National Credit Act. So because the HOA doesn't exist to extend credit to its members, the description of a policy that you adopt to deal with arrears shouldn't be called a credit control policy. A much better term is an arrears control policy. What sort of format and terminology should be adopted? Well, it's recommended that the policy should be reduced to writing. Where HOA executives have the power to make rules for the management of the development, this policy should be incorporated into those rules. Of course, sectional title trustees can't make rules, but they can adopt and publish policies, and our suggestion is that that's how it should be done in sectional title schemes. Let's look at the policy itself. It should be reviewed periodically, preferably once a year, to make sure that it takes account of modern circumstances. It should be communicated to all owners of units or individual properties in an HOA, at least when they first take transfer, and then after any amendment to the policy. The policy should be specifically referred to in any notice advising of the amounts and the due dates of any levy, so that they know this is what the trustees or executives of the HOA are working in accordance with. The contract with the managing agent should require that all administrative action be taken in accordance with that policy as amended from time to time, with of course the qualification that if the trustees or executives change the policy so that it involves a lot more work, then the managing agent will be entitled to amend his charges in regard to that part of his job. So let's finally look at what might be the content of such a policy. Let's start off with the sending of invoices and statements. After levies have been declared, owners have been invoiced and given details of the amounts and the dates of the installments due, there's no common law, principle or statute that requires that each owner or member be sent a statement each month showing the reconciliation of their account with the scheme or the HOA. The policy should specifically refer to this issue. To what extent statements are going to be sent monthly, less frequently, only on request. Exactly how will the question of statements work? That's really the issue that the policy should address. If the statements are not sent to all owners on a regular basis, it may be suggested that the scheme or HOA should debit the owners who receive statements with an administrative charge to cover its expenses in sending those notices, or that the managing agent should be entitled to render such a charge. Well, members have a right to know how much they owe the scheme or the HOA and how that amount is made up. And my suggestion is that the collection of levies from members is so fundamental to the operation of the scheme or HOA that the cost of sending payment reminders should be seen as an irrecoverable operational cost when those reminders are sent in the normal course. The imposition of a late fee, dealt with below, where this is allowed in terms of the scheme rules or HOA governance documents, is a more transparent and defensible way of recovering administrative costs associated with payment defaults. Notifications to owners of any special levies or additional charges, that should be dealt with specifically in the policy. How invoices, statements, and other communications in regard to the owner's financial obligations to the scheme or the HOA are actually to be delivered. Are they going to be sent by email? What is the process there so that people can know how to expect these things? This part of the policy needs to take account of the provisions in the scheme rules or HOA's governance documents in regard to the delivery of notices of any sort. Are there going to be any grace periods allowed? For example, a provision that levies are payable on the first day of the month, but no recovery action will be taken unless they remain outstanding on the 7th day of that month. That would be a reasonably normal sort of provision in that regard. In what circumstances will the scheme or HOA not initiate or suspend action against a defaulting owner? There are such circumstances, and they should be dealt with in the policy. Where overdue amounts are relatively small, the costs associated with recovery can be disproportionate. Just engaging the services of a lawyer has an initial hit, so you've got to be careful of that. A policy might, for example, specify that recovery proceedings will not be escalated beyond the raising of interest, late payment fees, and periodic reminders if a person who has a history of regular payments is less than 2 months in arrears. That's that's reasonably sensible, I think. Where the trustees, executives, or managing agent is aware that the arrears are due to a substantial crisis in an owner's finances, such as happens when a divorced mother loses her job and doesn't have the funds to pay the levy. Not being difficult, just doesn't have the money. A policy may require that the executives discuss with the owner whether or not that owner is able to sustain ownership. Is this short term? Is there another job 2 months down the track? Or are we really in trouble here? Do we have to think about selling the property? And where when an owner is making genuine attempts to sell their property, the trustees or HOA executives may wish to hold off legal action for arrear levies as long as they're kept informed of the progress towards transfer and the payment of the funds required for the issue of the clearance certificates. The next issue is what information in regard to arrear levies will be considered by the executives at their monthly meeting, and in what circumstances the executives will initiate direct communication with the owners concerned. So when owners are not able to make payments, the trustees or executives might, as a policy issue, say, yes, we will take specific steps. A missed payment followed by a standard letter from the managing agent and an entry in the monthly management accounts doesn't give them any insight as to why the payment wasn't made. If it is an oversight, if, for example, if an owner has a genuine problem or is disgruntled and believes that he or she has a reason to withhold payments, that is something they should know. That won't be apparent unless some non-threatening communication with the owner is initiated. The process of investigating an unexplained default in levy payment should, however, not delay the raising of interest and any late payment fee. And then finally, the timing and process of handing over the HOA or schemes claim to a professional debt collector. That also should be dealt with quite clearly in the policy. Thank you very much for watching this Paddocks Club video tutorial with me, and if you have any questions, we can deal with them in the Paddocks Club discussion forum.